When you're ready, please proceed.
Thank you, Mr. Chair, members. Earlier this year, the Center for Investigative Reporting revealed that our state government lacked a well-coordinated system to prevent fraud. Per the report, prosecutors are currently investigating and pursuing charges against more than 80 medical professionals who've handled more than 100,000 injured worker cases. Many of these medical providers have been charged with or convicted of fraud under a government healthcare system, but they continue to file and receive payment from our workers' compensation system. This is a classic example of the left hand not talking to the right hand, and it's simply unacceptable. The taxpayers of California deserve to have their tax dollars spent wisely, not wasted on fraud. AB 1244 proposes that physicians who have been suspended from participation in Medicare or Medicaid due to fraud should not be allowed to participate in California's workers' compensation system. There's an existing fraud notification system between Medicare and Medicaid, and AB 1244 adds the workers' compensation system to that successful fraud notification system. There are two technical amendments noted in the analysis. I'd be happy to work on the language of both of those with the stakeholders in our next set of amendments, which we will be adding disclosure requirements to best protect the interests of the worker. Specifically, I will be adding requirements that workers' compensation attorneys meet with the injured worker prior to performing legal services, tell the worker where the claim will be filed, and to prohibit payment of attorney's fees for any work done prior to meeting with the worker. In closing, I would just like to note that there is an estimated $1 billion in medical fraud cost to the state under the workers' compensation system. That's certainly unacceptable. We're always looking to put dollars to good use. This isn't a good use. This is kind of a no-brainer, good government bill, and we've got some folks here in support of the legislation with me.
So that you know, it's a great bill. We actually it's a good step in the right direction, and I just want to let you know we have support in this bill, so we're going to be good. And I think
Senator McGray, thank you for bringing this forward. It's very much common sense. $1 billion in fraudulent or inappropriate claims, if you will. So I'm happy to move your bill. Thank you for bringing it
it's
forward.
been moved. So
Senators.
please, if your witnesses in support, please.
Well, I can count. Barry Broaden supported the bill for the Teamsters.
Mr. Chairman, members, Theo Pejos representing ACIC in support.
Thank you.
Mr. Chair, members, Jeremy Merzmath, the California Chamber of Commerce. I have 14 well thought out points in support of this noble effort, but thank you for bringing the bill forward, and we certainly support the bill.
Wonderful. Any other witnesses in support? Any in opposition?
Good morning, Mr. Chair and members. I'm in the very awkward position of having to express some concerns about this legislation. I've read Mr. Baum's analysis. It's an excellent analysis of the bill. I want to make it clear that on behalf of the California Society of Industrial Medicine and Surgery, we strongly support efforts to prevent provider fraud and abuse in the workers' compensation system, and we applaud Assemblymember Gray's efforts to rid the system of the bad apples. I can tell you, as a lobbyist representing doctors, it's the bad apples that make my job that much more difficult. So if we can get rid of them, the sooner the better. I will be much happier. And I would certainly like to get my clients' names listed in the list of support of this legislation as it moves forward. However, there are a few serious drafting errors in the bill that we believe could thwart the efforts and could produce unnecessary friction and litigation. Our first concerns are found on page 13 of the bill with the proposed addition of section 139.21 to the Labor Code. Subsection A of the section requires the DWC administrative director to promptly suspend a physician or other provider from participating in the workers' compensation system in any capacity under specified circumstances. As drafted, that would prevent a suspended physician or other provider from being an injured worker, because it says you cannot participate in any capacity, and that includes injured workers. I don't think that's the intent of the author or the proponents of this legislation, to prevent a bad doctor from getting workers' compensation, or at least having a workers' compensation claim should that occur. So we would hope that that could be addressed. Second, subdivision A mandates the suspension for the conviction of any felony that occurred during any time during a person's life. As an example, you could have a person who was convicted of a felony in his 20s for street racing, or for maybe having a lid of pot in his pocket. Back in those days, 30 or 40 years ago, that was a felony also. But this person could have straightened out. They went to medical school, and they're doing care, taking care of injured workers. But the fact that they were convicted of a felony 20 or 30 years ago could cause them to be thrown entirely out of the workers' compensation system. We think that's excessive, and we would like to see that addressed. The third, subdivision A, mandates the suspension from participating in the workers' comp system in any capacity if the physician has surrendered his license. Many physicians, as they move away from the practice of medicine into other opportunities, or they simply want to retire, they voluntarily surrender their license. Merely the fact that they've decided no longer to practice medicine and voluntarily surrender their license, that should not be grounds to prohibit them from participating in the workers' compensation system, again, as an injured worker. It is one case. So we think those can be addressed. Our biggest concern, however, with AB 1244 is at the bottom of page 14 and the top of page 15 of the bill, where subdivision D of the new proposed section 139.21 prohibits a provider of services from pursuing a claim for payment for any services or supplies if the provider has been suspended, quote, unless that claim for payment has been reduced to final judgment or the services or supplies are unrelated to a violation of the laws governing workers' compensation. The laws governing workers' compensation, whatever that very broad category means. This prohibition, we feel, is ambiguous and is excessively broad. It can take years for a claim for payment to be reduced to a final judgment, and the services and supplies may have been provided years before the events that triggered the suspension even occurred. Furthermore, there may be absolutely no relationship whatsoever between the provision of legitimate medical services and supplies and the conduct that led to the suspension. The analysis indicates, and we've heard the testimony, that this prohibition is patterned after Section 14123 of the Welfare and Institutions Code that applies to Medi-Cal. That section is also modified by this bill. But in transitioning the Medi-Cal language from the Welfare and Institutions Code over to the Labor Code, there has been a glaring omission. Under Medi-Cal, physicians and other providers may not bill for services and supplies once they're suspended, but that prohibition does not apply to, quote, services or supplies provided prior to suspension, unquote. That's the Welfare and Institutions Code. That language, or that exception, is not carried over to the Labor Code. And in order to make the provisions consistent, if we're trying to make it consistent with Medi-Cal, we need to put that exception into the law in the Labor Code. We have shared some amendments with the author and with the committee that address our concerns. Ironically, one of the amendments that we have suggested would make the billing provisions tighter for workers' comp than they currently are for Medi-Cal. So we are suggesting an amendment that would make it even more difficult for a fraudulent physician to bill inappropriately for inappropriate services. Again, we strongly support anti-fraud legislation. We want to work with the author and the sponsors and supporters of this legislation and make this a better bill, a bill that will work, and a bill that will have less friction and cause less disputes, and that will get rid of the bad apples sooner.
Thank you so
Thank
much.
you.
I know any other witnesses in opposition will let the author and other witnesses close after the last.
Thank you, Chairman Mendoza. Steve Catolica, and I represent the California Neurology Society and the California Society of Physical Medicine and Rehabilitation in support of Mr. Brackensick's comments. And as unlikely as some may conceive the circumstances he described as being, that is the definition of an unintended consequence. We're here to be sure that the bill works, and we'd like to be sure that we get a chance to work with the author to make sure that it works ultimately. Thank you.
Wonderful. Thank you. Thank you. If you want to, I want to give the author an opportunity to answer some of the concerns that might have been brought up. I'm sure you'll be working with the opposition as the bill moves forward. But if you want to add or maybe dispute any of the things he might have mentioned.
Certainly, as you've heard, members, we've had some concerns raised here as to whether or not we've cast perhaps too wide a net. Better to err on that side when we're talking about $1 billion in fraud, but we're certainly going to work closely to address the concerns raised in a fashion where we're not having unintended consequences. We'll keep the committee informed of that progress, but nothing here that I don't think can be addressed going forward.
Wonderful. Wonderful. Senator Leno.
Could Mr. Brackenson please come up? Thanks. In the suggested amendments, you said you've offered the author. With regard to your first concern on page 13, with regard to participating in the workers' compensation system in any capacity, I think that's probably just sloppy drafting, and
Yes, sir.
I can't imagine there'd be any pushback there. With regard to the individual has been convicted of a felony, did you have some suggested language on that? Are
We
you
had some suggested language that would say that the felony was related to the physician's or practitioner's licensed profession or a felony involving moral turpitude.
Is moral turpitude defined in statute somewhere?
It's widely used in a number of statutes.
Okay, very good. So I was thinking, I wondered if you were going in that direction or potentially a time cutoff date, something that was 20 or 30 or 40 years old, but I think your direction's a wiser one.
Thank you.
So this is going to appropriations, should we pass today? So expect it all to be resolved before we'd see it on the floor. Good.
Wonderful. Okay, seeing no other comments from the senators, would love to go ahead and close.
Sure, I might just add to that dialogue, there's a constitutional right to the workers' compensation system that would trump the arguments put forth that this would exclude you from the workers' compensation system. But certainly, to your point, Senator, we can tighten up the drafting to make sure that that's clear.
Okay.
And with that, this is a good government bill, members. We're talking about $1 billion here that could be spent on essential services that I know this body would like to support. It's a simple connection. We do it in other elements to root out fraud. We should apply it in this circumstance, and I would ask for your support today.
Yes. Thank you so much for bringing it forward. We do have a motion already made, so we'll go ahead and ask Madam Secretary, please call the roll.
Motion is due pass to appropriations. Mendoza?
Aye.
Mendoza, aye. Stone?
Aye.
Stone, aye. Jackson? Leno?
Aye.
Leno, aye. Mitchell? Mitchell, aye.
Wow. We'll leave the roll call open for an absent member, and thank you. All right.